trial attorney Mark Eiglarsh. He cut his legal teeth as a prosecutor in Miami-Dade County, and he's here with me now. So officially, this is, in legal terms called a stinker, full of bad facts. But it's more than just bad facts. It's got an actual smoking gun. Eiglarsh, what do you do with this case if you're a defense attorney? Is there anything that you can bring into a courtroom?
Absolutely. No, I run to the closest sporting goods store. I ask where the knee pad sections are. I put those on and I go stand in front of the prosecutor and I fall to my knees and I beg for second-degree murder. That's it. I mean, that's really the magic. And when the prosecutor says no, you file your motions to suppress, meaning alleging that they might have obtained some of this incriminating evidence in violation of his constitutional rights. And when that doesn't work, you're forced to go to trial and likely he will be convicted.
The weird thing is the arrest was, legit, and the evidence was on his person, and pat-downs are part of the Fourth Amendment. I mean, that's not unreasonable search and seizure when somebody identifies someone, and the pat-down is right there on the site. They didn't go into an apartment and get the manifesto. In New York, it's already second degree, which is kind of weird anyway. But I thought you were going to say fall on your knees and beg for a plea deal. Is that not what they might be doing?
Yeah, no, I'm begging for a second-degree murder, a reduction from what will be a first-degree murder indictment. It's not going to stay at second. This was planned. They're going to upgrade it to first. And then you're going to beg for second to get maybe 15 to 40-year range as opposed to mandatory life without any parole.
I mean, this was an execution,
Oh, yeah.
So here's the other thing. I don't think you can even pull the whole diminished capacity or I was at my breaking point because my health insurance, because it turns out he wasn't even a client of this, of UnitedHealthcare.
Yeah, let's break this down. I don't want to take away from you analyzing it for weeks and looking into the minutia, but here's the bottom line. And I know lawyers who've been interviewed by family members, and if they're being honest, they're telling them, there's really nothing I can do for you if you're defining winning by getting him anything other than life. He's going to get life. The evidence is overwhelming, assuming what we're hearing is true and presumption of innocence and all that stuff, yada, yada. But if it really did occur the way we're hearing, the only thing missing is a busload of nuns who saw him do it. Otherwise, this is a slam dunk case for prosecutors.
Yep, slam dunk, layup, you name it. That's kind of what I thought you'd say. Mark, I always love having you on. Thanks for doing this. Appreciate it.
My pleasure.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.